Dana Goldman is a former federal prosecutor, and he joins us tonight. Mr. Goldman, thank you for coming on.
My pleasure. Thanks for being here.
So you just heard Jonathan Turley make, I thought, a good point, and one I've heard others make before, that this has been going on for a long time, not just in this administration, but in previous administrations, where the Department of Justice withholds information inappropriately from Congress, claiming that that information is classified, and when unredacted, it turns out to have been not classified. In other words, they were lying. Why would anyone ever defend that practice?
Well, these things can often be subject to interpretation, and the prosecutor may have some belief at an initial stage that there are, or the Department of Justice may have a belief at an initial stage that things may be classified either in relation to that case or in other cases, or there may be some theory that it is classified. The defense attorney disagrees that it's and says it's not classified, and ultimately a judge decides it. This is no different than
okay, so
any
let me give you an example. Yeah, this is a little bit different. So, for example, the Department of Justice, the Trump Department of Justice, I'll say, withheld this information from the Congress, that Andrew McCabe spent $70,000 on a conference table. Now, you could argue that he had a right to do that, or it was appropriate, or whatever, but you can't argue that that information is itself classified or critical to American national security. That's butt covering. Why would anyone defend that?
Well, you're trying to hone in on one particular reason why things are redacted or why things should not be.
What would be the justification for redacting Andrew McCabe spending $70,000 on a conference table?
I don't know, and I don't know the detailed circumstances. I think the point that I would want to make to you, and listening to what Jonathan Turley just said as well, first of all, as we're looking at these as redactions and we're looking at the oversight role into the Department of Justice, I think you have to draw a very clear line between investigations that are over, such as the Clinton email investigations, and investigations that are ongoing, such as the Trump-Russia investigation. And there is a long-standing practice that the Department of Justice does not give over information relevant to ongoing investigations to Congress. And that's something that the House Intelligence Committee, through the use of their purported oversight role, has sort of done away with and is trying to get it.
When you say purported oversight role, do they not have an oversight role?
They have an oversight role, but
what do you mean purported oversight role?
Well, they're using the guise of their oversight role to ask for information that they should, either that they should not get, or that they are potentially and by many accounts coordinating with the White House and others who are the subject of the investigation. That's entirely improper.
Look, I understand that you're a partisan involved in a partisan debate, but take 3 steps back. There's a public interest here. So we know that the last administration had a paid informant spying on at least 3 members of the Trump campaign. Now, maybe there was a good reason for that, maybe there wasn't. But the fact of it is true, and it's known by the public. And the fact of it shakes the public's faith in the integrity of the Department of Justice. So why wouldn't responsible people do their very best to explain why the hell that happened as soon as they possibly can and calm public fears that the system is corrupt? Because the public is beginning to believe it is, including me. Why wouldn't we have the right to know why that happened?
I actually think I'm not at all partisan. I think the people who use the term spy in the context of a confidential informant are doing so only for partisan reasons, because a spy does not exist within the FBI. So when you're going down that road of using a spy, the simple
answer... What I'm doing is speaking plain English, and what you're doing is carrying water for a political party. I am saying that they spied on members of the Trump campaign. They gathered information without the knowledge of the people they were speaking to.
Which happens in thousands of investigations. It happens in thousands of investigations across the country.
It may, but it doesn't answer the question, which I think I have a right to know, which is, why did that happen?
You don't have a right to know.
This is not normal. This is not...
You don't have a right to know. Investigations are confidential. FBI investigations are confidential for very important reasons, including the protection of people who aren't charged, including for the protection of sources and information, such as confidential informants. You don't have a right to know.
I understand. Actually, I would disagree with you completely, and I know that you are a former prosecutor, so coming at this from a different point of view, obviously. But we know that this happened. No one is disputing it happens. We know the names of the people involved. And so all of that information is public. It's been in the New York Times. You don't acknowledge that there's a public interest in explaining this to the public so they can trust their government again. Why was the Obama administration spying on the Trump campaign? You don't like the word spying.
I don't dispute that there is a public interest. I don't dispute there's a public. There absolutely is a public interest. It is outweighed in the current moment by an ongoing and confidential investigation. The public does have a right to know at some point after the ongoing investigation is not jeopardized.
So then why are people like me who are asking honest, in my case, sincerely nonpartisan questions, like, how the hell did this happen? Why am I being attacked as someone who is challenging the rule of law or seeking to undermine the system? My position is I'm trying to preserve public faith in the system with sunlight. I mean, I thought that was a traditionally liberal position, is it not?
I agree with you, but all I'm saying is that there absolutely is a public interest. I do think that you and others have a right to know what happened during the course of an investigation, just not while the investigation is going on. And that's the critical difference. By preserving the rule of law, you have to preserve the confidentiality of the investigation so witnesses can't tailor their testimony, so sources are protected. Okay. Ultimately, it will all come out, and you do have a right to know, and that's why I draw the distinction between the Clinton email investigation, which is over, and an ongoing investigation where this confidential informant is very relevant.
Daniel, thank you for that. I appreciate it.
Thank you.